welcome to the daily newspaper analysis, which is brought to you by LawSikho. Happy Monday to all of you, and we all wish you a very bombastic, energetic, and enthusiastic week ahead. So let's see, what do we have for our discussion today? We have an editorial that has been taken up from the Indian Express. The title of this editorial is An Exceptional Justice. It is actually a very interesting article, and I would really suggest all of you to go through this article. It talks about the Perarivalan case and the recent release that has been brought forward by the Supreme Court. So who he exactly is, and what was the case, and why are we calling this as an exceptional justice, will be discussed in this article. Secondly, we'll be moving forward with the news update for the day, wherein we'll be discussing the most important news points, awards, appointments, sports news, etc. that can be directly asked in our prelims exam. And thirdly, we'll be discussing the legal news that will be covering the most important latest case laws for the day. Also, guys, if you like this discussion, do not forget to give it a like. You may also subscribe to our channel and also give your good comments to us as a piece of motivation. With this, let's start the discussion for our day, which talks about an exceptional justice. So the Supreme Court has released A G Perarivalan in a fight for freedom that spanned for 31 years. And this case forces us to reckon with the legacy of tyranny of terror laws and broader crises that plague our criminal justice system. I know huge, heavy words and jargons have been used right now. Let me just break this down into very simple language for you all. So let's first understand, guys, that who exactly was A G Perarivalan. Now, as you can see in this picture as well, A G Perarivalan was one of the convicts in the Rajiv Gandhi assassination case. Now, as you know, guys, back in the 1980s, the early 1980s, Rajiv Gandhi, who was the then president of India, he was assassinated in a bombing, and my bad, he was the Prime Minister of India and he was assassinated in the bombing. So A.G. Perarivalan was one of the convicts. Please mind here, I'm not even saying accused, he was one of the convicts of this case. But the sad part of the story is that A.G. Perarivalan, the kind of crimes, the so-called crime that he was actually convicted for, and he spent 31 years in jail. The only crime that he had committed was he had bought and brought some batteries, these LED, like these lithium batteries. So he had bought some of these batteries, but he did not really know that what was the purpose of buying those batteries. Now, let's say, for example, that if I ask you to buy me a knife, you do not know that what is the purpose of this knife, and you just buy it for me. Now, you might be thinking that I need this knife for maybe cutting an apple, but in my head, I need that knife to maybe murder someone. So in this case, do you think that you as an individual had any liability over here, because you definitely did not know that what was the purpose of this particular thing that you were being asked to buy? And similar was the case with A.G. Perarivalan as well, when he was asked to buy some batteries, but he did not know that as to for what purpose are they going to use these batteries. And ultimately, those batteries were used to make the bombs and all the things required for that assassination scenario. So here, after 31 years, A.G. Perarivalan has now been released. So this actually talks about the thing that how has our judicial system become so tyrant, and the laws, the terror laws that we have, the terror control laws, for example, we have the TADA, UAP, etc. How have they become so stringent in nature that we are not even able to dispense the basic justice amongst the people? So 18 years after the Supreme Court upheld the Perarivalan's conviction, it was submitted in a sworn affidavit by Thiagarajan. Please note here that Thiagarajan was the then investigating officer of the state. And after 18 years that the Supreme Court had upheld the conviction, then was Thiagarajan, he came up and he said that he had omitted the part where Perarivalan had mentioned in his statement that he did not know the use of the batteries he was buying. Now, guys, can you imagine the plight? Can you imagine that how big a blunder was this on the part of this investigating officer, that he did not mention that this person who has been accused, and later he was even convicted, that he had mentioned that he did not know the real purpose for which those batteries were going to be used, and he omitted this particular thing from Perarivalan's statement, and due to which he was convicted, and he had already spent 18 years in jail, and he in total spent 31 years in jail. So this shows the vicious reality of our criminal justice system, where the evidences and statements are altered to obtain the convictions. So it also demonstrates the danger of conferring extraordinary powers to the police for the sake of investigation. Now, guys, this has been, as much as we talk about, might not really be enough. That the problem of custodial torture, custodial deaths, as well as the improper investigation that has been taken up by the police in many kinds of cases, that has definitely come forward, and we really need to raise a voice against it, at least at this point of hour. So further, his death row sentence. Please note here that he was even actually, he had given death sentence as well, but later it was, reduced. So his death row sentence was confirmed in complete ignorance of the Bachchan Singh framework, which talked about giving the death sentence only in the rarest of the rarest cases. And guys, if I'm not wrong, I had read it sometime before that he was only 19 years old while he was convicted in this particular case. And now you can imagine that he must be 50 years old, like now, when he has been acquitted from the trial. So he was 19 years old, and even at that particular time, Bachchan Singh case framework was not paid any heed upon. So Perarivalan spent half of his 31 years of imprisonment as a death row convict. Now, can you understand the kind of torture, kind of plight, the kind of trauma a person must go through, that he even did not do anything like of that sort that caused the assassination, and still for half of the 31 years of span, that is for approximately 15 years, he spent the time in the jail in the death row, which means that he had the fear of death, that is of death penalty, every time lingering upon his head. So the death sentence was turned into life imprisonment only in 2014 by the Supreme Court due to the inexplicable delay of 11 years that it had already taken up. So, further, the 2018 recommendation for release made by Council of Ministers was denied by the governor, and here the governor was constitutionally duty bound. He was mandated to do so, and yet he turned a blind eye towards the same. So, finally, it was the Supreme Court that invoked the extraordinary powers under Article 142 and released Perarivalan. Now, here is a question for you guys. Please pause the video. Let me know in the comment section if you know what Article 142 of the Indian Constitution entails. If you know what is it about, let me know in the comment section below. And this shows the humongous effort it takes to change the course of an injustice in the Indian judicial system, which definitely is not something to be celebrated about, but unfortunately, it is a part of the Indian justice system. So, what should have been a norm, what should have been a general thing, has indeed become an exception in the Perarivalan case. And we should all note that here, as we say generally also, guys, that, basic trial, jail, when we say, jail is an exception and bail should be the rule. Similarly, we say that, general imprisonment or general conviction should be a rule. And only in the exceptional cases, such harsh punishments like death penalty should be given on the rarest of the rare cases only. But definitely that was not followed in the Perarivalan case, to say the least. With this, let's move further with the news updates for the day. Sangita Kalanidhi Awards, Sangeet Kalanidhi Awards. So the Music Academy announced the Sangeet Kalanidhi and other awards for various artists from the years 2020 to 22. So that Sangeet Kalanidhi will be given to renowned vocalist Neyveli R. Santana Gopalan, eminent Mridangam artist Tiruvarur Bhakta Vatsalam, and violin duo Lalgudi G.G.R. Krishnan and Vijay Lakshmi. You might not be able to remember these names, but just remember that Sangeet Kalanidhi Awards have recently been given. Secondly, Manchester City won Premier League title. So in a league title final that sent the fans of football over the moon, Manchester City won the Premier League title for a fourth time in the 5 years after surviving an almighty scare on an incredible final day of the season by Liverpool FC. Thirdly, 250th of birth anniversary of Raja Ram Mohan Roy. We all have definitely heard his name sometimes before. So one of the most influential social and religious reformers of the 19th century of India, Raja Ram Mohan Roy was born on 22nd May 1772. So 2022 marks his 250th birth anniversary. He is widely regarded and known for his work in the field of women emancipation, especially the abolition of sati, along with Lord William Bentinck in the year 1829, and modernizing education and changing religious orthodoxy as well. Fourthly, Biodiversity Day, that was there on 22nd May. So biodiversity remains the answer to several sustainable development challenges, and that is why we celebrate the Biodiversity Day. The slogan for this year was Biodiversity Day 2022 is building a shared future for all life. Now let's see what do we have for the legal updates for the day. Firstly, Section 106 of the Evidence Act applies to cases where chain of events has been successfully established by the prosecution, says the Supreme Court in the case of Sabitri Samantaray versus State of Odisha. Secondly, the Hindu Succession Act, HUF, that is a Hindu undivided family, property is presumed for a widow's maintenance when she has it settled and exclusive possession, says the Supreme Court. So the Supreme Court observed that settled exclusive possession of the property of an Hindu undivided family by a widow would create a presumption that such property was earmarked for her pre-existing right of maintenance. Now, this is particularly true if surviving co-partner has not already done the same. Here, again, there is a very interesting question for you all. When we talk about the co-partner, we say that a person who has the right in the property by virtue of its birth, because a person is born in a particular family, that person will be a co-partner. Now, can you tell me that is only the male child or also the girl child a co-partner? So, who exactly is a co-partner as per the latest laws? Let me know in the comment section below. And this above given situation, or the above given thing was held in the case of Munni Devi alias Nathi Devi versus Rajendra alias Lallu. So this was all for the day. We hope you liked the session. Do not forget to like it. And if you want to download the PDF of today's slides, you can join our Telegram channel. The link is there in the description box below. Thank you so much.